Good afternoon, everyone. Thank you so much for joining us. First, I want to say that we have a collection of both students and practitioners here for CLE credits, which is great. CLE practitioners, please be on the lookout for the code and submission instructions that will be dropped into the chat at some point during the presentation. Next, I want to inform everyone that this event is being recorded by IU. This year, the Indiana Journal of Law and Social Equality has decided to break up our usual day-long symposium and provide a series of events centered around examining race inclusion in the law. While we're excited to use our existing platform to further promote social equality in this area, IU Maurer Law School and several student groups are hosting events on these issues throughout the year and hopefully beyond this academic year. As a school-wide initiative, many students and faculty have been reading Alexander's books, The New Jim Crow, and coming together for discussions and other events surrounding the issues presented. IU's BALSA and SBA have partnered up to headline several speakers. Their first event was last week, and they have more coming up. The Big Ten law schools have been putting together speakers every Tuesday evening as part of their Perspectives on Race, Law, and Equality series. Next Tuesday, October 27th features IU's own Professor Jessica Eaglin. And this Saturday, APULSA is hosting a discussion on affirmative action, and particularly SFFA versus Harvard. This and more events through the university can be found on IU Maurer's event page. Today, the Journal of Law and Social Equality is very excited to have Anton Robinson and Marta Nelson here to discuss their research and experiences working in criminal justice reform. First, Anton will present, and then Marta, and then they will take questions. So if you have questions, please hold on to them until after the presentation and then drop them into the chat. If you have a follow-up or a clarifying question, feel free to raise the little blue Zoom hand and we will come by and unmute you. We also request that if you have the ability to turn on your camera, it makes the presentation a lot nicer for everyone, and we would really appreciate it. Completely up to you, of course. First, Professor Anton Robinson has more than 15 years of experience of criminal court experience and served as an assistant public defender in New York City and in Orlando for almost a decade. He's a senior planner at the Vera Institute of Justice, a nonprofit national research and policy organization that works to build and improve justice systems that ensure fairness, promote safety, and strengthen communities. His present work at the Vera Institute centers on mass incarceration, youth justice, racial bias in the criminal legal system, money bail, and restorative justice. Anton works with New York City and national organizers to upend harmful policing and prosecution practices. He's an instructional systems designer. He teaches race, crimes, and restorative justice at Vermont Law School. And Anton is a member of the Criminal Courts Committee and Mass Incarceration Task Force of the New York City Bar Association. He's also served as the secretary of the Criminal Law Section of the Metropolitan Black Bar Association for the past 2 years. Anton has a JD from the University of Florida Levin College of Law and a BS in Mass Media Studies from Florida State University. Marta Nelson has worked on the criminal legal system reform for close to 30 years now. She joined the Vera Institute of Justice in 2019 to write on sentencing reform, particularly sentencing involving people convicted of violent offenses. Prior to joining Vera, she served from 2014 to 2019 as the Executive Director of Reentry and Special Counsel for Criminal Justice Initiatives in the Office of New York Governor Andrew Cuomo. She guided legislative and administrative changes that reduced barriers affecting people with criminal convictions and helped the state deliver comprehensive bail reform in 2019. Previous positions include Executive Director of the New York City Office of the Center of Employment Opportunities, an organization that helps formerly incarcerated people find and keep jobs after leaving prison. During her previous tenure at Vera, she was the director of Vera demonstration projects, Project Greenlight, and Adolescent Portable Therapy. Marta began her public service career as a prisoner rights attorney at the Legal Aid Society of New York, following her time in a private law firm and in a judicial clerkship. She has a JD from the University of Michigan Law School and a BA in Religious Studies from Brown University. Thank you both so much for being here. I will turn it over to you now.
Great. Thank you, Audrey. and to the Indiana Journal of Law and Social Equity for having us here today. It's really exciting to be able to have this conversation, one that we think is important to what's happening in our criminal legal system. And what better time to litigate some of these issues together. And I say litigate, that's the litigator inside of me, to discuss these issues together and to try to think of solutions together. So in order to maximize time, I'm gonna jump through our conversation. Let me share my screen. Okay. Somebody give me a thumbs up that we have the screen. Can you see it? There we go. Okay. So we have sort of, and I hope it's not too awkward, but we sort of characterize this conversation as one about the doors to the criminal legal system. That is, thinking about how people enter into the criminal legal system and then how they exit out of the criminal legal system, the encumbrances for many of getting out of that system. And so today we'll talk about those. We have characterized the front end or the front door as more of a conversation about bail. Certainly there are other pressure points on the front end of the criminal legal system. And then the back door, the back end of the criminal legal system being more about sentencing. But again, you'll see that some of the issues sort of converge, and that it's important not only to think about those two pressure points, but to think about everything that's happening between them as well. And so as a bit of framing, and let me get rid of myself, it's sort of hard to look at yourself when you're speaking. As a bit of framing, I want to talk a little bit about what mass incarceration actually is in our country. So from a big picture standpoint, how many people are actually incarcerated in the country at this time? About 2.3 million people are incarcerated. And that is a 700% increase since 1970. And we incarcerate these people, our family members, our loved ones, our society in 1,833 state prisons, about 11 federal prisons, over 1,700 juvenile correctional facilities in our country. And then something that I'll be zeroing in a little bit more on is the 3,134 local jails in our country. And I'll be speaking about this local jail population because it is a huge portion of the incarceration pie. We know that approximately 470,000 people are incarcerated right now who have not been convicted of any crime. So just under 500,000 people being held in without a conviction. And so in terms of the front door, that is the framing for this conversation. What are some things that we can do to close this front door or to limit it so that we are not sending so many people away to jail? And to just illustrate the various different pressure points within, obviously, again, bail is not the exact first thing that can happen. There are a lot of interventions out there that are aimed at keeping people, not even arresting people, keeping people at their homes, giving them warnings. And certainly a lot of diversion programs out there that even at the point of arrest or after the point of arrest might stop someone's case from being diverted or going to the prosecutor's office. And same thing on the back end, the back door. There are many different ways that we can keep people out or get people out sooner. And I'm super excited for the conversation that Marta is gonna sort of spark in a few moments. But you can't be here in this moment without having a little bit more of a conversation about that front end and about what policing means for so many people in our society. Give me 1 second. So you all have no doubt been tuned in to the various strategies to reduce instances of police brutality. I've included a quote from Dr. Janine Bell, who takes on, or discusses rather, the defund the police movement. And you can see different instances all around our country, and probably see them personally or in person, excuse me, where the issue has been brought up. What do we do about policing? We have various instances where Black and Latinx people are being the targets of police brutality, and what can we do about it? And one of the rally cries against it has been to defund the police. And so I bring that up, not so much to discuss it politically, but to raise it as sort of an academic approach, right? We're seeing people through their calls to defund the police have very different stances on what that actually means. So some people mean it in a more theoretical context, right? Some people mean it very literally. There's an organizer and teacher by the name of Mariam Kaba. I think it was July. There was a New York Times article where Mariam Kaba says, no, I actually, the title of this article was, yes, we mean literally abolish the police. And so some people take a very, very sort of black and white approach to what it means to abolish the police or defund the police. But I tend to think that many people look at it in the same way as Dr. Bell, who says that defund the police doesn't mean that there will be no funding for police, period, but rather that police in the defund condition will only be involved in the investigation of serious crimes like murders. And so I want to bring you back to Mariam Kaba's article, and I feel free to take a look at it later, but there's something that Mariam Kaba said that was interesting. Says that the point of discussion is that police officers don't actually do what we think they do. The idea being that we have this sense that police officers are out solving murders every day, or that they are investigating robberies every day. And she quotes, and I don't know the exact statistics on this, but she quotes that if an officer arrests someone for a felony charge once in a year, that is sort of an officer that is exceeding the bounds of what many officers do. Now, obviously, I was a former public defender. I know that there are different units and that is not to be taken literally. But the point is, it is very clear that officers in many instances are patrolling communities and that they're not always doing exactly what we think of officers doing. But more than that, and more precisely to Mariam Kaba's point and to Dr. Bell's point, is the idea that in order to get closer to what the solution looks like, officers cannot prioritize these low-level offenses that continue to lead to skirmishes with people from specific communities, and including the Black community. And so bail, right? So what happens after an officer is in contact with someone and they are taken to the precinct? They end up in criminal court for arraignment. And I've had the opportunity over the past 3 years to really dig into bail and bail reform and what it means and different approaches. But the reality is, a lot of my understanding of bail and the things that I know about bail come from my time as a public defender and speaking with my clients and doing my best to get bail as low as humanly possible, or to have my clients released, if at all possible, in arraignment court, so that they don't have to post bail. It is that I saw how much of a burden it was for my clients to post bail, how much it meant that they could not often have food or clothing or new clothing if they needed it, And there, in a very real way, around the holidays, it was a real thing for them to say, I don't have enough to get my kids anything for the holidays. So I sort of understand bail and much of the criminal legal system, both academically now, thank you, Vera, but also in a very sort of tangible way, just learning from my clients. So I raised that because that has sort of shaped who I am. Give me one more second. So the big picture is about bail as it relates to the Eighth Amendment is simply that the Eighth Amendment prohibits the use of excessive bail, but it doesn't define what excessive means, or specifically when bail should be granted. And so the core of the bail fight has been that most state constitutions include provisions guaranteeing a right to bail. A typical right to bail provision might say all persons shall be bailed by sufficient sureties unless for a capital offense, so very, very serious offense like murder, where proof is evidence or the presumption is great. What that has yielded in our society is more of a conversation about what excessive means. So as someone who's represented a ton of people in criminal court in about 10 years, you know, excessive, the definition of excessive for me meant that my clients couldn't afford it. It was clearly excessive if they did not have the ability to post bail and to be released, to go home to their families. But that is not everyone's definition of bail, and the Supreme Court has, that is not necessarily the definition of bail from the Supreme Court either, but it certainly is the point of attack that many advocates, many attorneys are making across our country. And so I just highlight a few cases, 1951 case, Stack v. Boyle, Supreme Court case, where the Supreme Court provided some guidance in assessing what excessive bail was, starting from the premise that traditional right to freedom before a conviction permits the unhampered preparation of a defense and serves to prevent the infliction of punishment prior to conviction. And so you'll see that case cited often for people like me and you know, organizers, people and legislators who are working to change the bail laws, to say that the goal is not to punish people on the front end. They enjoy a presumption of innocence, one that is supreme, and we have to live up to that. And then another case that I would ask you all to just take a look at when you have an opportunity, another Supreme Court case in Salerno, or United States versus Salerno, says that if the only asserted interest is to guarantee that the accused will stand trial and submit to sentence if found guilty, then bail must be set by a court at a sum that is designed to ensure that goal and no more. Again, it gets down to the crux of the issue, which is how do we ensure that we are not detaining people simply because they cannot afford to post bail. And so fast forward to 1984, our country had a lot of conversation in the 60s, 70s, and 80s about bail, and that relates obviously to crime trends at the time. And we leave in 1984 with the following guidance, which is that the Bail Reform Act of 1984 said that it laid out three fundamental changes in bail law. And it allowed the court to deny bail to those who pose a danger to the community. That's going to be a really, really big theme in some of our bail conversations today. It created more categories of people who would not be eligible for bail, including the potential flight risk, repeat offenders. And then it established the necessity of bail hearings for any person who might not be eligible for bail. And why is this all important? It's important because the average felony bail in the United States is about $10,000. But there was a recent Federal Reserve study from 2019 that says that $400 would be an imposition, very difficult for most of us to make. I think it was 40% of the people in the United States could not make $400 bail if it were set. And to illustrate the reality of that, I've had clients over my career who have been in jail pre-trial, so presumed not to be guilty, who have been in jail for 6 months, 7 months on $1,000 bail or $2,000 bail. Now, the reality in those circumstances is oftentimes the person will plead out so they can get out, or as a defense attorney, I would file motions for their release under those circumstances, but there's no guarantee that that would happen. And I've seen, actually lived through those horror stories with my clients and their family members. And then more than that, it does impact the outcomes of their cases, right? Like they can't show me where to go to investigate. We can't go to the scene together. We can't talk to witnesses together. And so it really does hamper a person's case, and the evidence shows that the outcomes are worse for people who are held in jail pre-trial. And that's when we're talking about just about their charges. But think about the outcomes for employment, think about the outcomes for their homes. Many people lose their apartments or housing altogether. And then think about those very real things in their lives, like their family members. The United States increased our use of bail in the 1990s. So in 1990, we used bail at about 37% of felony cases. And in 2009, 61% of felony cases had bail set. And we, of course, have to talk about the disparities in bail, which are simply that bail amounts tend to be higher for Black and brown people who appear in arraignment court. But more than that, that they have bail set more often. So you'll see that Black and brown people are at least 10 to 25% more likely than white people to have to be detained, pre-trial, and to have bail set. And then I'll note that young Black men are about 50% more likely to be detained pre-trial than young white men. And the reason this is also important is this bail industry. Like there's a full-on $14 billion industry in our country related to bail, and that involves private bail bond agencies. And the problem there is that you have the people with the least resources being forced to go to bail bond agencies to try to get out. So that is, we're talking about mass incarceration. So we don't lead into a conversation so much about what is happening for the people who are able to get out, but I'll just simply leave you with the idea that just because they're out does not simply mean that they have access or resources in the way that they would need to get about society and to do well in society. Many of them stretch their entire families to the brink to try to get to post bail at huge risk to their families. They go without food in many instances and without the other necessities of life. And so I will sort of summarize, and we can talk a little bit more about this in the question and answer session, but I want to make sure that we get to the sentencing conversation. But there are many different efforts here going on in our society now that aim to change the way that bail is administered, right? So bail reform efforts. So there are efforts to remove money bail altogether. Alaska and New Jersey are two examples of that. And the goal is to sort of do away with money bail such that the only people who are held in, if at all, are the people who pose the most risk. And risk is a really, really important conversation. It's one that I think it could be a conversation in and of itself. But if we think about societal concerns about bail, it goes to that issue. Like, how do we determine a person's risk? Is there a way to do that? Are the methods that we use to determine a person's risk, and what I mean is something we alluded to earlier, is either the risk to reoffend is how it's often characterized, or the risk to public safety, and then the risk of not returning to court on time or for future court appearances. And so that's more indicative of the risk-based models, and of which there are many as well. I want to also talk about some of the stopgap measures that are used in bail reform efforts. And the reason I do that is to highlight one of my own in a few moments. But there's, you can look all over the country and see different examples of bail funds. So different organizations that are posting bail on a person's behalf, with the goal of both getting people out immediately, but also making a commentary about the necessity or lack thereof of bail. And bail reform, bail funds organizations have been useful in the bail reform fight. I don't usually say the word fight, but in the dialogue about bail reform. So while it appears certainly that the Criminal Rule 26 doesn't lay out an absolute right to bail, Indiana has been making efforts to make bail less burdensome than in the past. So in 2017, there was a pilot that included 11 Indiana counties. And what they did was they applied the use of a risk assessment tools, we just talked about risk, to work toward getting more people out. And so it was, just a few points about it, in that it was a tool to determine a person's risk to the community. So not just one related to whether the person would come back to court. So you saw a lot of questions about that person's criminal history, if any, the severity of the crime, and so forth. And if released, the judge would then determine whether the person is to be put on pretrial monitoring. And the idea was to prevent, again, lower income people who are charged with less serious crimes from being held in jail. And again, that tends to be the sort of reoccurring mantra or theme around bail reform, and certainly an important one, and maybe one that we can think of different ways to achieve that. New York passed bail reform last year in April of 2019, and it was implemented on January 1st of 2020. And briefly, it required the mandatory release of most people charged with misdemeanors and nonviolent felonies. Again, low-level offenses. How do we get people out? And it allowed judges to consider a person's ability to pay bail, and whether bail would be a hardship for them to make. And also, it required judges to set alternative forms of bail, like unsecured or partially secured bonds. And that's simply like a form of bail where the judge will set a bond amount, let's say $10,000, but allow the person to be released merely on their promise that if they don't return to court, they will pay the full-on bond amount, the full $10,000. That's an unsecured bond. And in a partially secured bond, there's a percentage of that bond, so up to 10%. So the judge could allow them to pay $1,000 and be released, along with the promise that they would pay the full amount. The reason that's important is the very people who are forced to go to bonding agencies don't have that option in many instances, because it was not used as much as it could have. And so they were forced to go to bonding agencies where whatever portion, and we hear 10% often, but whatever portion it is that they would have to post to be released, they would lose that to the private bonding agency. And so in this sort of iteration of the law, this requirement allows them to do a similar version of that through the clerk of courts, with the benefit being that they'll get their money back at the end of the case. And so I am going to be very brief about a project that I helped to launch at Vera. It's called the Bail Assessment Project. And it's one where we went straight to the issue of ability to pay. Our research told us many times in the past that the issues often come down to whether people can afford to post bail. How do we attack that? Now, I principally am all for bail reform. I want to see money bail go away completely in our society. I think there are ways to do that, and certainly ways to get toward that. This project is one that encourages that by telling courts just what is possible when we actually consider a person's individualized needs. And so what we did with it was we created essentially an ability to pay calculator. And I used this slide to show some of the factors that we considered. I will say that we have thought about the calculations over and over and over again. And I am sort of, and this is just a personal opinion, I'm sort of left with the idea that one of the utilities in a project like this is more about raising awareness that everyone who stands in front of a criminal court arraignment judge, newly charged with a crime, and sort of waiting to see what will happen with their case. They're individuals, their circumstances are different. They have different amounts of money, they have different resources, different kids. And so what we sought to do was to really lean into that and to factor in not just whether a person is employed, which some other models have done in the past, and not just what their amount of money coming into their homes are, how much money they make, either from benefits or otherwise, but to really think about their individual circumstances and really think about their income, their benefits, as well as their assets, if they have any money in the bank anywhere, as well as their expenses. And that is a big issue, particularly in expensive cities. I live in New York City now. So it's a big issue where people make okay money, but their expenses are excessive. And so that has led us to a broader approach to bail reform that allows us to really, really zero in on the issues. And so I'll say that one of the sort of findings from that project was simply about how many people that we assessed had very, very little money. More than 60% of the people that we spoke with had no ability to pay whatsoever after we sort of calculated their ability to pay. And that really is just analyzing their disposable income. And so as framing, this leads many people to be in jail pre-trial, and we know that there are collateral consequences for that as well. That include whether a person might take a plea and be sentenced. And that was my terrible attempt at a transition to my colleague Marta's presentation about sentencing. So thank you all. I'm going to toss it to you, Marta, at this moment.
Hi. Okay, folks, I can't see my screen. I mean, can you see a screen that says sentencing?
No, it's not sharing, Marta.
I'm not sure what's going on. Okay.
Oh.
Is that working?
Yes, but we just see your computer desktop.
Okay, let's try. Okay, guys, sorry, we even tried this before and it was working and I have no idea what's going on. So I guess, I don't know what to say.
Oh, there it is.
Okay, so that's the very beginning of the slideshow. So let me just keep going and find it. Okay, and are you seeing just the slide or are you seeing like little notes?
Just your slide.
Okay. All right, so hello everyone, I'm Marta Nelson and we're just gonna whoosh now from the point of conviction to the point of sentencing, realizing there's a lot that's happening to an individual in between those two. But I would say that the whole thrust of this conversation is about decarceration. And Anton has talked a lot about how having fewer people come in the front door is a way to decarcerate. But to decarcerate our prison system, and this next slide will show you, we really need to do more than what we're doing right now. This slide shows the huge increase from 1970 through the beginning of the 2000s, which has started to go down a little as of 2017 of this slide. But if we continue on our current rate of decarceration, we won't get to where we were in 1970 until 2166. So the level of sentencing reform that we're doing right now needs to be entirely rethought and entirely ramped up. And so in order to do that, I mean, this is just a little bit more about why we have so many people in prison. It's because we send so many people convicted of felonies to prison and misdemeanors. 50% of people convicted of misdemeanors have prison time, 70% of felony convictions. And this is completely different than the rest of the world, in which those percentages range from 5 to 20% for felonies. And people are spending a lot of time in prison. In 35 states, at least 1 in 10 people has been in prison for 10 years. And the Sentencing Project put out this really fascinating report this year that showed that there are more people serving life sentences in the United States right now than were even in prison at all in 1970. So we have significantly upped the number of people in prison and how long they're staying there. And indeed, this has a racially disparate impact, as you can imagine. The percentage of Black and Latinx people in the prison population is 57%, and they comprise only 29% of the general population. And of people serving those very long sentences, the life sentences, the virtual life sentences, nearly half are Black and another 15% are Latinx. And this disparity in sentencing occurs even when you control for the crime and criminal history. So how do we get here? It's our belief at Vera, and we're writing a paper on this, which will hopefully come out at the beginning of the year, so stay tuned, that you can't really begin to talk about sentencing reform until you tackle two dominant narratives that have got us to this place. Because wherever you go, you're gonna end up right back here. If you're walking into a state house and you're talking to legislators, you're gonna end up at these 2 points. And the first one is that incarceration equals safety, that we have incarcerated our way to safety, and that we do that through a combination of deterrence and incapacitation theories. Now, the folks of you you're either law students or you're lawyers, so hopefully this rings a bell. Deterrence means we'll make the sentence so bad that people will be deterred from committing crime, and incapacitation will just keep people inside and therefore they can't commit crimes. And then the second sort of dominant narrative is just about retribution. Essentially, that's the term. You do the crime, you do the time, and that your harsh sentences, your just desserts for what you've done. And when you come around to it, people's support for current sentencing structure really comes down to one of these two theories. So these theories are very resilient, but they are false. And so we're going to describe how they are. So the first one really has to do with this sense that people have in the US that crime is endemic. This is a slide from the Gallup poll. And every year the Gallup poll asks people this question: is there more crime in the US than there was a year ago or less? And as you can see, that percentage that people have said more, most people think there's more crime each year. And that's absolutely false. Crime has been going down in the United States steadily since the early 1990s, where it hit its peak. People keep thinking it's going up. Why? Things like local news coverage. If it bleeds, it leads. And crime is just really first and foremost in our political discourse as well. You see that this election cycle, there's been a lot of talk about law and order and, you know, what's going to happen if we are not tough on crime. And that sort of bringing together of politics and crime, or stoking fears of crime to lead to law enforcement solutions and then sentencing, really began in the 1960s, kicked up a bunch with Nixon in the early 70s, Reagan, the war on drugs. All of it is just really inextricably linked right now for a lot of Americans, and it's almost instinctive. Like, the way to be safe is to go after crime through law enforcement and through our judicial system, including these very harsh sentences. How do we counter this narrative, which is just really endemic in our society? Well, we would say you have to look at facts, not fear. And there's basically 5 facts that we're trying to get across. So listen up. I'm going to go through them quickly. First is that a huge crime drop that we've seen from the 90s to now, that was not caused by us incarcerating our way out of it. The National Academy of Sciences put out a report in 2014 that looked at all the studies that had been done on this topic. And they concluded that while there was evidence of some reduction due to incarceration, if you put in, you know, as many people as we do, if you up the rate of incarceration the way we have, you may have a little bit of effect, but the magnitude of the crime reduction, how big this was, is basically highly uncertain, and the evidence suggests that it wasn't large. So that's not what caused this giant crime drop. 2, deterrence. It doesn't work, basically. People, when they're committing, you know, making either decision to commit a crime, oftentimes it's not a decision, it's something that happens without thought. But when people are sort of weighing whether to engage in criminal activity, they don't look at the severity of the sentence. They look at, are they likely to get caught, and how quickly they're going to get caught. Those are the things that really drive behavior, not severity. 3 is that people grow up and stop criminal behavior long before these lengthy sentences that they are forced to serve. We know that violent crime in particular, measured by arrest rates, is much more prevalent among younger people from late teens to early 20s, and that their rate of being arrested for these crimes drops precipitously and is in half by their mid-30s. And that's because people mature neurologically. There's a lot of brain development that goes on, personally, spiritually, and they don't need to be incarcerated for these lengthy sentences as an incapacitated measure. Next, violence. People are very concerned about violence. You know, there's been a lot of talk about we can reduce incarceration by focusing on drug offenders, nonviolent, people convicted of nonviolent offenses. That's not true. Essentially, if we only focus on those crimes, we wouldn't really move the needle for decarceration. About half the people in state prison are in there for violent crimes, and in some systems it's much greater. So unless you sort of start to think about violence, you're never going to really move the needle on reducing our size of our prison population. So let's talk about violence. Some facts about violence. First, there are very few violent predators. If by predators, we mean people who commit crimes over and over again, violent crimes over again, serious violent acts. 50 to 70% of violent acts are committed by only 1 to 3% of the population. So it's really a question of finding those folks, and there aren't that many of them. Amongst most people convicted of violent offenses, and that would be, the people who aren't those repeat specialists, there's very little evidence of a specialization in violence. Most violence is situational, meaning it arises in the heat of a moment. It arises because conflict between specific people. It is not then generalizable. Many people who commit violence or themselves victims of violent crime, and they can have untreated trauma that can make these moments of conflict spark into unplanned lashing out. So the resulting violence is not good. It creates real harm, and we aren't trying to minimize that at all, but it doesn't create an ongoing safety crisis that must be addressed with ever increasing amounts of incarceration. So there's a difference between harm and safety. Indeed, for whatever reason that people commit violence, this evolving out of crime phenomenon that we talked about earlier applies especially to people who committed violent acts because people age out of violent crimes at an earlier age than drug or property crimes. And the last sort of fact about fact, not fear, would be that incarcerative sentences can make society less safe. So if you put in the numbers of people that we have into prison, you are removing people from their communities, and their communities don't have breadwinners, they don't have people working, they don't have fathers, mothers. That kind of connective tissue that holds a community together gets weakened when you remove enough people into incarceration. Plus, prisons aren't a great place to be, and some people who may, have not been inclined in that direction can learn a lot about how to be a good criminal when they're inside. So you want to be very careful about putting people inside prison who don't, absolutely, quote unquote, need to be there. So the second narrative, so that's about safety. Second narrative is just, they did something bad and they need to pay for that. Back to that old mantra, you do the crime, you do the time. That requires a literal outing of a person from society. You give them that label, convict or inmate, you separate them from their family or friends, you're putting them in this deliberately dehumanizing environment. This is vengeance, and you are outing someone because of that. And calling it vengeance isn't to say, we're sitting on some moral high horse, like, whoa, people shouldn't do vengeance. People do vengeance. People's been around for a long time. It's evolved. I mean, the evolutionary psychologists have looked at this, and this sort of vengeance response to harm is a universal human response to exploitation or harm. So it's not that people are acting illogically when they really want to lean into vengeance or retribution. But it often creates a lot more problems than it solves. When you sort of fight back, this thing bad happened, I'm going to respond with this bad thing. This can create a cycle of tit for tat. And that may seem remote in the context of the state bringing on the vengeance, excuse me. It's still a setup for more pain down the road. The person can emerge from prison more bitter, worn down, so that they either live up to this out status that they've had, oh, well, I'm a convict, I'm gonna just live that way. Or again, their removal from the community destabilizes the community, which can create disrupting and harmful behavior. On a broader societal level, when the state just comes down hard, enacting vengeance on its own citizens, its own residents, creates pain for those who question the legitimacy of these actions. It creates a real questioning of the state's role in the criminal legal system, particularly when visited upon Black and Brown people. And fundamentally, vengeance, or retribution as it were, is relying on a deterrence theory. It's about signal setting. Like, I do this to you, this is what's, you do this to me, this is what's going to happen to you. And as we've learned, it just doesn't work. Deterrence does not change people's behavior. So as tempting as it sounds, vengeance is not a way to address criminal behavior. Fortunately, we have another option that we also have evolved over time to deal with harm, and that's called repair. And repair is a strategy that is used for people's in-groups, their families, their communities, people whom you have an ongoing relationship with and you need to invest in that. So when they harm you, you can't just out them because they're part of your community, they're part of your family. So what do you do instead? There's another strategy, it's called repair. And repair consists of action or actions to address the harm with the harmed party if possible and with the larger community as well. It gives the person who harmed someone a way back into the community. In response to their actions, they're able to stay in the group. And this concept of repair and reconciliation is not limited to small grudges or slights. They can be deployed for major breaches of trust and serious harm. The more serious the harm, though, the more reparative and rehabilitative work needs to be done. And we would argue that the state is uniquely positioned to opt for repair as a response to harm. Why? Well, because the state is the only entity out there that has all of us in one community. You know, people have their families, they have their communities, those are smaller groups. The state is the only one that's going to look at every single one of its residents as a member of its community, and every single one of its residents that has sort of needs to be kept in the in-group. There's value in keeping them there as opposed to just shoving them out. So we think that the state needs to sort of move into this position of repair. So that's sort of the theoretical framework. I know I threw a lot at you, but let's just look at what this would look like if we really held on to these two principles, which is that you don't really incarcerate for safety in most instances, and that repair should be the way forward. It means that if you're looking at a sentence for somebody, the place you'd start with would be freedom and liberty. You'd start with the presumption that that person doesn't need to be incarcerated. Liberty is a fundamental right. It's in the Fifth Amendment, it's in the 14th Amendment. And you would incarcerate someone only for those truly dangerous people. I remember I talked about that 1 to 5% of people who commit those repeat violent offenses. You would identify those people and you could incarcerate those folks to keep us safe. Or when you have serious harm, say murder or something like that, and you're doing a process of repair, but you can't start that immediately. You need a period of separation in order to start that process. Sometimes you just need to go to your corners, and incarceration could play that role, at least at the outset of a case, but not for like 20, 30 years by any means. Now, that's kind of a radical rethinking about how we use prison. And I don't think that we're going to be there tomorrow. So just want to talk a little bit about some reforms that are happening that are a way to get us to that North Star, and that are, you know, certainly in current discussion in a variety of states or in the federal government. So if you're interested in sentencing reform, there is work happening on the ground that you can key into. First is to eliminate mandatory minimums. Mandatory minimums are just what they sound like. They are a requirement that someone, if you are convicted of a certain crime, you have to serve X a number of years in prison. Those mandatory minimums are just used as a cudgel by prosecutors to sort of force people to plead to things, because there's no discretion, there's no ability for the judge to look at circumstances behind a particular case. So they're very blunt, and they don't need to be here. Second would be to eliminate bars to alternatives to incarceration. Alternatives to incarceration are programs that people can be sent to instead of prison, as the name suggests. There are things like drug treatment, there are things like work programs, counseling, they happen in the community. Someone might be on probation while they're going through those, but they're often not permitted for people convicted of violent offenses. And so for all the reasons we've stated, people convicted of violent offenses, with the exception of those very few sort of repeat serious offenders are not different than everyone else. They deserve this right to have an alternative to incarceration, just like everyone else. And eliminating those bars would go a long way towards giving those people an off-ramp from incarceration. Next reform would be to eliminate enhanced sentences based on prior convictions. And this happens all the time. I mean, sort of the most egregious example of it is a 3 strikes and you're out type thing, where your third felony, you can end up with life in prison, which is the case in several states. But it also just happens when, you know, it's your second felony and you therefore by law have to have a higher sentence. And what those do is they really punish people twice for a crime when they've already served the sentence for that crime. Like when that person did the first thing, they served their sentence. And then the second sentence shouldn't punish them twice for the same crime, which these kind of enhancements do. In terms of harm, the harm isn't greater to someone, the fact that someone has done this crime before. The harm that the victim experiences is the same, and therefore we shouldn't be elevating the sentence. They also really add to the racial disparity that we have in sentencing. Because Black and brown people are targeted by police at higher rates, they have a lot more convictions than they should, just in terms of their behavior. And then this ends up being sort of a huge enhancement to the kinds of sentences that they get. And so if you eliminated enhanced sentences based on prior convictions, you would go a long way to reducing some of the racial disparity in sentencing. Another reform that's out there now is the idea that the longest that someone should serve in prison should be 20 years. So 20 years in max instead of, say, like life. The Sentencing Project is as a whole campaign around this. And basically the idea is that even the most serious crime, whatever safety or retributive or separation purpose that it might serve, by 20 years, it's served that purpose. So you should be done. And again, in the rare instances that you have somebody who just literally cannot walk the streets, think, you know, serial killers or something, there would be a way to be able to hold that person longer if there is a ongoing safety risk through more like a civil confinement process. And finally, the last reform would be to allow people to earn time off their sentences. That used to be just the way things were until the 90s, when there were changes to truth in sentencing laws, which really reduced the amount that people could earn off their sentences from good behavior while they're incarcerated. And being able to sort of remove those barriers and allow people to earn the time off would be a way to help reduce the amount of time that people spend in prison. And it's good because it's an incentive, it's a carrot. People, behave a certain way while they're incarcerated. They engage in certain programming. It's good for them. It's good for the community. And it's a way to reduce that kind of incarceration. So I'm going to talk for 2 minutes about another form of back-end sentencing options, and then we'll be happy to take your questions. So the sentencing reforms that I've been talking about thus far are all about what's on the statutes, what's available to judges as they're setting out a sentence. These back-end sentencing options are for people who are already serving a sentence, a way of then removing them from that incarcerative sentence. First is parole, for states that have indeterminate sentencing. That's when there's a minimum and then a maximum, and somebody's in until the minimum and then they can see a parole board. And that's about 2/3 of the states have indeterminate sentencing systems. The problems with parole board deciding to release people is that it is an intensely political process. Parole boards get hauled out to no end when someone that they have released then goes on to do something bad. Whereas the thousands of people that they release that don't go on to do anything bad, there's absolutely no press about that whatsoever. So parole boards are very much incentivized to not let people out, because if they do, when something bad happens, it's their head. So therefore the release rates are quite low. They hover around in the 25% range. They vary from state to state, but nationwide it's it's not particularly high. And the other sort of back-end sentencing option is something called a second look provision, which is brand new, this idea. Cory Booker introduced a piece of legislation in the federal, for US sentencing last year. The idea would be at 10 years, a person could petition for resentencing, and that would be discretionary. A judge could do so if the judge found that there wasn't a safety issue, an ongoing safety issue, that the interest of justice would be served, whatever that means, and that the person was ready for release. They had taken part in sort of preparation for release programming. And the model penal code sentencing, and I think at least back when I took criminal law, we used to look at the model penal code for, so those of you who are studying that now, there's a new version of the model penal code that has to do with sentencing that came out in 2017. And they had this idea of that everyone should have the ability to petition the sentencing judge for resentencing if they've served 15 years. And so far, that has not been taken up by any particular state, but that idea is out there, and it's certainly getting some talk, at least among people who talk about sentencing reform. So that is the end of our presentation. We will now just, I will figure out how to stop sharing my screen, and we can start talking. Okay, did I figure out how to do that? No, you're probably all looking at my,
there it is.
There we go, we're out, we're free. Okay.
Thank you guys. Thank you both so much. Those were fantastic. So for everyone here, if you want to just drop questions that you have in the chat, if you'd prefer to raise your hand, then I'll unmute you. That's totally fine as well. But while you're formulating those, I do have a couple just to sort of kick us off and discuss a little bit more. So Anton, you touched on Indiana, which was really great regarding bail reform. And I was wondering if you could talk a little bit more about issues with risk assessment, because that is what Indiana is planning to do. And I've read a lot of issues with risk assessment. And I'm wondering if there's any way that you've seen that can sort of do where there's a fair way to do risk assessment, if that makes sense.
Yeah, it's a good question, and it's one that I personally think about quite often. The issue sort of brings me back to something that Marta raised, which is that some people have prior criminal records that they simply should not have, or that other people who are comparable don't have, with comparable, or people with different backgrounds or different color skin. Have simply, they don't have it, and sometimes for reasons not related to them. And so with risk assessments, you get those sort of baked in inconsistencies as well. But I do believe that if we are to have the conversation about risk assessments, we should be really, really thinking about ways that they're validated, so they take into context some of those inconsistencies and disparities. And then they should continue to be validated over and over and over again to ensure that they are not increasing disparities. And I mean, the real point about risk assessments, and that we have that conversation so much, is that we should be thinking about it should be such, not a remote conversation, but we shouldn't even have to get to the point of risk assessments for so many of the crimes that people are being held in on bail for. So like, that's my perspective as I still sort of think about it academically, is just that they are used in some states, but we should really we shouldn't like focus in on that so much that we like don't think about the real issue, which is that like, we shouldn't even have that conversation for tons of crimes.
No, that makes sense. And then Marta, it looks like David posed a question that might go a little bit more towards your presentation, but it's probably to both of you. In your opinion, what has caused the drop in crime?
Yeah, that's a great question. There have been a few studies that have suggested some things contradict each other. The Brennan Center did a study in 2016 that isolated a couple of factors, including the police management technique, a better police being able to do a better job of finding crime, that sort of hotspot policing, dropping numbers of people in the age group that are prone to crime. So, you know, through the 60s, the 70s, you had the baby boomers, you had just a big cohort of younger people, and you had crime going up during that age, and that people in that age cohort have been going down. Dropping alcohol consumption, growth in average incomes are some of the factors that they found. Also, if you look sort of overall, there's been not only in the United States, but in Europe and for a lot of developing countries, just an overall decline in violent crime, including homicides over the last 50 years. But interestingly, there was an article that just came out a couple of days ago from 538, which I recommend, which is a lot about this sort of tie between crime and politics, that says that we may never really know what caused the crime drop because crime is cyclical, and some of the factors that happened here didn't happen, say, in Canada, and yet crime dropped in both places. So in some respects, we may never really know, but we know that it's not tied to our law enforcement, you know, to locking a whole bunch of people up.
And I'll just add a little bit to that in that I'm very excited about restorative justice. Marta referenced that in her presentation, but we see many different restorative practices. I guess I should be clear about restorative justice. It is this idea that we should get to the root cause of the crime. So why did it happen? What does the victim or the complainant need to be made whole again? This idea that the person who did it needs to take accountability and responsibility for it. And that we should be committed as a society to reconciliation, right? This principle has been around maybe 40, 50 years. It's not the oldest concept in its application to the criminal legal system. But what I really think is important about it is it challenges us to get to the root cause of it, the need, like why the crime happened in the first place. Again, more to what Marta was talking about. And so that to me feels to be important in moving forward as a society, is to really diagnose how we got here and what we need to get out of it. And I mean, you think of restorative justice as putting two people in a circle and asking them to hash it out or to figure out their how we got here together. But I kind of feel like that's a metaphor for what we actually need to do when we see higher rates of Black and Latinx people being prosecuted or brought into the criminal legal system, period. Like, we need to have the hard conversation in individual communities to figure out like why that's happening and what led to that. So that to me feels to be, and I should say in terms of the impact, we've seen some restorative justice measures, particularly with reference to diversion programs in youth justice setting, be very, very helpful to keep young people out of the criminal legal system. And so I think more of that energy is needed.
Thank you both. Just a reminder for people to drop questions in the chat, but let's see here. So, and just so we know, I'm gonna have to jump off, and Willow, who's also on our journal, is gonna take over to end the, wrap up the conversation. But Marta, I was wondering, I've noticed that you worked a lot on community reentry programs. And so I was wondering if you can talk about some state initiatives that have been successful on reentry, looking at reentry.
Sure, yeah, so that was one of my previous lives. I get to do a lot. I've had the privilege of doing lots of things. So reentry, I think reentry is really having a moment right now when there's been sort of a recognition about the barriers that we placed on people, that these are, you know, the race has been sort of collateral consequences of convictions, I would argue they're not collateral. I think that's pretty central to the whole outing of people, is to make it a permanent other status. Things like inability to vote or inability to hold a job or get housing. But I do think there's a lot of focus on that across the country. And I would say it's not particularly, it can be fairly nonpartisan as well. So I spent many years on the employment side helping people find jobs when they get home and working to displace sort of employers' fears about hiring people with criminal convictions. I think that some major advances recently have been this idea of statutorily removing some of these barriers. So starting with things like expungement. So just last week or 2 weeks ago, Michigan passed and the governor signed sort of the biggest expungement bill out there. It's for misdemeanors and some nonviolent felonies. I think for misdemeanor, you have to be like 7 years from the last one, and felonies maybe 10. But it's automatic, meaning it's retroactive as well. So those things are just off your record. You don't have to apply for them, which is how many states have that construct now. Pennsylvania has it and Utah has it too. And these are all just in the last 2 years. Around things like making discrimination against people with convictions illegal in things like employment and housing. New York, I have to give a shout out here. It's been illegal to discriminate on the basis of employment since the 1970s in New York. We're one of the few states that had it for so long. Does that mean that people still discriminate? You bet they do. But it means that you can actually challenge that. And there's been some really upped enforcement of that in the last few years in New York. And many other states are starting to do that. Also sort of buoyed by an interpretation of the EEOC that says that because there is this strong correlation between convictions and race, that to discriminate on the basis of conviction means that you are having the effect of discriminating on the basis of race, so that people can't have a blanket policy of not hiring people with convictions. So it feels like there's a lot of energy around that. And I know that there's a bunch of national organizations that are doing work on this: National Employment Law Project, the Collateral Consequences Clearinghouse, the Alliance for Safety and Justice has a campaign called Time's Up, I think, which is just to work on reducing these collateral consequences in a variety of different states. So there's a lot of energy around it. And I think that it is fairly nonpartisan. Even, we worked on a ceiling bill in New York when I was there, and the DAs actually supported it and were pretty instrumental in getting it passed.
Thank you so much. So I'm going to ask a question from the chat, and then Ray, I see that you have your hand raised, so we'll get to you right after we answer the question from Emma. And I think this is for both of you, but the question is, do you think that there's space for restorative justice practices in public defense, or is advocacy that change is happening predominantly outside of governmental agencies? And she said that something she struggles with is reckoning between politics that sort of drive people to public defense, but ultimately anybody in public defense work is taking a paycheck from the government that also implements, the sentencing and the bail structure that that some people find immoral.
Yeah, it's a great question, Emma. And it's something that as a person, as a public defender, particularly in New York City, and I felt very, I wanted more power. You know what I mean? Like I wanted my clients rather to have more power. I wanted the courts to understand more about my clients and wanted them to be appreciated as full human beings with a backstory and that I thought was relevant to why they were there. That's even before we talk about guilt or innocence or anything else. And so I felt in New York City, for example, about 3% of indicted felonies actually go to trial, right? And so I'm like, how is this justice? Like, how do we achieve that? And so I would go 9 months without having a trial. And I'm like, how am I defending someone when I can't get to this fundamental trial right that everyone told me about and that I experienced in Florida? How do we get there, and how is this justice? So it absolutely led me to wanting to understand how we got here, how the criminal legal system could function in this way. Principally, I didn't ever feel sort of ethically concerned about it, and that was because of my clients. Like, I stood next to people every day, like helping people and helping them to understand how the system worked. And so that to me always made me feel really, really proud about that work. I'm still very proud about that work because in a way I'm helping sort of demystify like what is going on in the criminal legal system. And that's really a part of my job today as well. In terms of restorative justice, I think that well, first of all, it's a great question because it makes me think about the class that I just created and taught. And that was really what we sought to do, which was to incorporate restorative justice into this broken or shattered, depending upon how you look at it, criminal legal system. Can we incorporate restorative practices into it? And I got that same tension from all of my students, which was that like I don't want the system. I want to abolish the system. I don't want to create anything that works inside of it. And so all I can say, Emma, is that you're asking the right questions. And I think you might go back and forth on what the answer is. But I do believe that restorative principles should be incorporated into our approach to a solution, because if nothing else, it forces us to ask the right questions. And we haven't been asking the right questions in our society.
Right, and I would have a slightly different take on that. I mean, I think you're absolutely right that we haven't been asking the right questions, and that it's great for a public defender to have tools that look at their client as a person. But there are some advocates that are against restorative justice because they see it as outside the adversarial process, and they don't want something that's going to have their client admit their guilt or have to like if they're going to do that, like it's almost like outside of the scope of the representation, and they wouldn't advise their client to do that. And to me, I don't agree with that. I think that it may, I guess it depends on how the systems are set up, and whether that if someone goes through a restorative process, if they can avoid incarceration as a result, yes, you'd want to have that set up as sort of the path. But I think their client can actually end up a much more whole person if they do go through this process, if they do engage in this process of repair, because like going through the adversarial system and maybe play out and maybe you get some sentence and it's not that long, but that doesn't help them do that sort of work of figuring out what they did, how did it affect someone else, and it's not going to make anything better, I don't think. But there are public defenders who feel quite strongly that restorative justice cannot sit within the adversarial system, and they will sometimes steer their clients away from it.
Yeah, and I want to add too that some of the restorative approaches within criminal cases, they started out like that way, but by the time that you make them fit into the infrastructure that currently exists, then they lose their restorative power. So one little example when it goes to taking accountability is there was a program in Florida where the prosecutors would ask for the client to write an apology letter on lower level offenses, so petty larceny, things of that nature. And what ended up happening is the clients, and it became a part of their plea, like it was like a condition of their plea. And so whenever you use the word sort of condition, you are required to do this by such and such time, it really does take away the restorative goal of it, because it becomes a condition, it becomes a mandate, and it takes away sort of the real nudge to be contemplative about the way that you cause someone harm. And so I think we lose a lot when we incorporate restorative practices into this already broken system. So I guess that sort of tends to add and to add more confusion to your question, Emma. But
I guess it depends on what those practices are, and we paint it with a kind of broad brush, but I think there has to be, you know, more research done as to what good practices are, and to Anton's part about sitting in a circle, like you don't put people in a circle until they're ready to be in the circle, and there's a lot of background work that needs to go into that. So it can end up doing more harm than good if people aren't prepared for that work. So I think a lot more investigation and research on the restorative practices, which, you know, have been going on in various places, but that needs to get lifted up, and there has to be sort of a body of practice before we, you know, just say to everybody, okay, go sit in the circle or write the letter, right?
Absolutely. And Ray, I'm going to go ahead and unmute you now so you can answer your question or ask your question.
Hi there. So one of the things that I was curious about, Marta, was your comment about political or parole board or parole review boards being very political, and that one of the reforms would be to have judges reconsider sentencing after 10 years or so. And one of the things that I was curious about, and forgive me, I haven't taken criminal procedure yet, but one of the things I was curious about is if this were the case, I would assume that it wouldn't be an appeal, but that it could go back to like a district level judge or a fact-finding judge. And a lot of times we're talking about crimes that are adjudicated at the state level. And when we're talking about crimes adjudicated at the state level, we're talking about elected judges. And we're talking about judges that oftentimes run on a platform of tough on crime because they're coming from a prosecutorial background and now they're stepping up to the next level. And so if this is the fix where we have judges relook at sentencing, but the judges are also elected, you know, what is the risk of judges becoming politically radioactive because they are now reconsidering sentencing and letting criminals that they have perceived as being a low risk to society and back
No,
on?
I think you're absolutely right. I mean, this is a new idea. I think it's loaded with just those problems that you've cited. I mean, parole boards it's political. Elected judges, it's political. I think people it was a bunch of judges who came up with this idea at the American Law Institute, the Model Penal Code Sentencing. Many of them are federal judges, so they have more insulation. And also judges tend to think very highly of themselves. But I think in a state court system where you have mostly elected judges, you're going to run into the same problems, which is, I think, that relying on a back-end solution is ultimately not going to get you there. That you have to make it a legislative solution at the outset to just make these sentences not available. I think it takes a lot of political courage to go back and say, you know, yeah, it's hard. Yeah, maybe if you're appointed, you could get away with it. Another idea is to have a panel of judges. So it's not one judge, it's the commission of the second look panel. And therefore you can't point the finger at any one person.
Thank you.
So I know we're getting close. I'm not seeing any questions in the chat, but does anybody else want to raise their hand, offer something in the chat, ask a question to our wonderful speakers?
I just dropped our email addresses into the chat. If you have any questions or want to discuss further, feel free. I meant to do that earlier, but I don't think we got to the last slide with our information on it. So feel free to email. It's been exciting to talk to you all. And if you have any further questions, let us know. Happy to answer them.
And also you can contact Audrey with the IJLSE. We'd be happy to share this information as well. And just thank you both so much for taking the time to speak with us. It was really, really interesting hearing your perspectives on sentencing and on bail reforms. So I just want to thank you for taking the time with us.
Great. Well, thank you for having us. It was nice to be able to talk about these things with a group of interested folk.
Absolutely. Thank you all.
Bye.